Welcome back to Sunrise. Mr. John Oloide joins us now. He's a legal practitioner. And then we're just going to review some of these cases as the AFCC, some of the cases. First of all, Mr. Oloide, thank you for joining us this morning. But there's this matter which we'd like you to just shed some light on. There was this case about, it's a money laundering case actually. The courts it had to do with this $300,000, a Chinese national, and then the federal government. Now, the AFCC had arraigned this, some of these names are not that easy to call, Li Yangping, before the court on March 21, 2018. And this was after his involvement in money laundering to the tune of $300,000. Now, the AFCC's action, we understand, was sequel to receipt of information from Nigeria Customs, which informed the Commission about the failure of the Chinese national to declare the said $300,000 during his outbound clearance for traveling to Dubai via Emirates Airline. Now, the matter came up in the court, but the judge couldn't sentence him because I think they said he was coughing. And so the judge said, look, if they had sentenced him, chances are that he would infect some of the other persons who he may be exposed to. So that couldn't happen. And AFCC, from their comments here, not quite happy with some of those. So these are some of the challenges of COVID. But first of all, what usually is the case with this kind of matter? What's the penalty for this kind of offense?
Well, I must say from the onset that the decision of the court is quite surprising to me too. That a matter that started in 2018, and when it's time for judgment, after leading evidence, both sides, I understand that EFCC led evidence, and the accused person also led evidence. That's a matter that started 2 years ago, and when it's time for judgment, the court suddenly raised the issue of COVID and says, oh, no, I cannot sentence him to jail, to a jail term, so that he doesn't infect other inmates. Now, that's quite surprising to me. And while I must say from inception that I am not privy to the records of the court, except there is something that is not in public domain that is on the records of the court, that kind of decision is, with all due respect, very, very wrong. Now, COVID-19, usually in matters of this nature, there is room for forfeiture. Part of the sanction is to forfeit the proceeds of the illegality, which is the $300,000. The judge was quite right on that, 100% forfeiture. But that does not rule out the imposition of a jail term on the accused person, especially where a case has been made out. It depends on the head of claim, but I believe there was only one count charge. It was only a one count charge. And to that extent, I believe the penalty, the sanction is between 5 to 10 years, minimum. That's jail term. The judge has a lot of room to exercise discretion and all that. I also believe that this particular accused person must have been on bail. He wasn't in detention. He wasn't on remand. And so I still find it difficult to understand why the jail term would not be imposed. Now, it is not out of place for the court to say, well, before the man is alive, he is not exhibiting advanced traits of COVID-19. Are you with me, Chamberlain?
Yeah, we can hear you.
He's not exhibiting a very clear trait. He was present in court. The proper thing would probably be for the court to say, okay, I am sentencing you to jail on condition that you will be isolated for so many days, just like any other person, for you to probably undergo treatment or for you to be watched to see whether, you are not going to go into any deeper state of the ailment. And then after that, he can start serving his jail term.
In other words,
yes.
If you can, so that means that him coughing, whatever that meant, was not or not tenable as an excuse for him not to have been sentenced, because he could have been tested, he could have been sentenced, and then being in isolation, serving the sentence upon when he recovers. Is that the case?
The Money Laundering Act never envisaged a situation where somebody will cough in court or show that you are sick in court, and because of that you will escape jail term. No criminal statute, no statute on that sanctions criminality will say that because an accused person is sick or exhibiting traits of a sick person, then he should be free from jail term. It's just like saying, somebody who has committed murder or committed armed robbery and has been found guilty by a court of law, and then the court says, okay, between now and the time when you will face the hanged man, you will have to be on remand. But I can't put you on remand because you are showing signs of coronavirus 19, and so I will let you go. But all the proceeds of your criminality, you have to leave them here. What kind of justice is that? It is not part of the law. The fact that somebody is coughing, I mean, anybody could have been told to say, when you get there, just start coughing. It could even be told to drink coffee so that the temperature will be high, so that when they check his body is hot and all that. That cannot be part of the law. That cannot be the intendment of the drafters of the, what's it called now? The Money Laundering Act. That is not law. If he is sick, even if he is sick, if an accused person is sick, it's not even about money laundering now. Any offense whatsoever. The proper thing was for the court to say, the law is very dynamic. The law is made for men and not meant for laws. When there is something that arises, the court is allowed room to now exercise discretion, especially where there is no clear-cut provision for that. It doesn't mean you discard the law simply because I don't want to put some people in jeopardy. The proper thing for the judge was to have told to have given the decision that you are entitled to so many years jail term, but in the interim, I want you restricted to an isolation center. The isolation center could even be a 5-star hotel, probably because the judge feels that the man who the accused person has white skin. Well, one of the tenets of the rule of law is that we are all equal before the law. People are being jailed right now, Nigerians. They are going to jail right now. Even this period, they are being sentenced to death. Last week or so, one was done in Lagos. And the heavens did not fall.
You know, there's another matter which also involves some Chinese nationals. This was Zamfara, a road contract that was awarded. It turns out that that road contract wasn't done. They attempted to bribe AFCC officials in Sokoto relating to this particular case. And then there was when the minister, I think the Minister of Mines and Steels, made reference to some of the high-profile persons who they say some of them were working for, including some illegal miners in Osun as well. As a result of that, the government there are under pressure to let some of these things go. So there was questions about, in that case now, when they talk about those high-profile persons who are there, and if the matter is under investigation, would it be out of place for the authorities to name these high-profile persons if they do know them?
Oh, why not? If parties have been cited, names have been cited, however high-profile they are, that's the basis of what I said earlier on. If there is actual rule of law, the law does not respect your status, your office, your personality. Everybody must come to the law equal. So if a suspect has mentioned the names of high-profile individuals in the Nigerian society, now the proper thing is for the law to run its course. That is the ideal. I'm talking of the ideal. You are a Nigerian, I'm a Nigerian. We all know that when the chiefs are down, the rule of law can always be jettisoned. And that's why there are situations, the case we talked about now, I believe it has to do with the color of his skin. The people that have been mentioned now, Now, because of that, you probably will hear that you may not hear the conclusion of the matter. You may the case will just fizzle out like that. There will be no arraignment, there will be nothing. And then we all forget about it. Nobody follows up. Journalists, Nigerians, nobody is interested again. But the ideal situation is, irrespective of whose name has been mentioned, the important thing is that nobody should be punished without having his or her day in court. If anybody, a suspect, mentions other people as accomplices, the proper thing is for the law enforcement agency to call them in, let them make their statements, and let the enforcement agencies determine their culpability or otherwise. That is the proper procedure. Whether that will play out in these matters you have mentioned, I may not be able to say. That will be a matter of conjecture on my part, which I should not do. But it should be the right thing that these people will be called in. The person who mentioned it, they should face each other, and the person should, yes, you are involved, you are the one, you are my financier, you are the person who is actually sending me on this errand, and this is how we share it. Let the man deny it, and then let them investigate.
Given the relationship with between Nigeria and China and these cases that we have also raised, do you see any likely diplomatic issue coming out of any of these cases?
Well, Chamberlain, this is about sovereignty. Nigeria has laws. In China, you cannot imagine a situation where even what we toy with here, where EFCC, they charge people to court, and then before you know it, they say there is a plea bargain and a lot of funny things happen. You don't hear in China that number 3 or number 4 or number 2 has been charged to court or before the appropriate panel in China for bribery and corruption, and it goes court-free. In fact, they have capital punishment for some of the things we toy with here. You steal money, you are guillotine. The top of the head in China. And it's not like here where, you have stages and stages and stages. Yes, you can go on appeal and appeal, but it's as certain as day and night that if you are caught stealing, especially from public coffers, you are a goner. Now, if they will do that to a Chinese person in China, and the Nigerian is caught in China, are you going to cite diplomatic relationships in telling them to suspend the implementation of their laws, so as not to disturb the cordial relationship between us? In implementing laws, diplomacy, especially when it has nothing to do with international law, what has been breached is our domestic law, Nigerian law. As a country, we have the prerogative to implement our laws to the letter. If the Chinese have been mining without license, endangering lives, bringing in mercenaries to protect their illicit trade, and they get caught after so long, this has been going on for ages. Zamfara has been a hotbed for the criminal activities because of the criminal activities of these people. If they now get caught, you now say because we are debtors to China, because we keep borrowing from China, they keep on building rail lines and all sorts of infrastructural development are taking place because of our collaboration with China. So the Chinese can walk in, breach our laws, and just walk out like that. Then what happens to the Nigerian who breaches the same law? Why should we punish them? That is rule of law. That's what I'm saying.
All right, Mr. Oloyede. Well, appreciate your thoughts this morning. Thank you very much indeed, Mr. John Oloyede, a legal practitioner. So we'll just be back to take a look at your comments in a moment. Don't go away.